curiam. A judgment rendered in per incuriam cannot be accepted as precedent. The question thus arises, what do we mean by the term per incuriam? In practical terms, per incuriam means per ignorantiam, meaning thereby if a judgment has been delivered in ignorance of a statutory provision or a binding case law, the said judgment is per incuriam and cannot be accepted as precedent. This doctrine of per incuriam was initially developed by the English courts. In our country, a constitution bench of the Honorable Supreme Court of India in the case of Bengal Immunity Company versus the state of Bihar reported in AIR 1955 Supreme Court page 661 followed this principle, which was subsequently reiterated in other later judgments. In the case of Municipal Corporation of Delhi versus Gurnam Kaur, the Honorable Supreme Court has held that a decision should be treated as given per incuriam when it is given in ignorance of the terms of a statute or a rule having the force of a statute. In another judgment, in the matters of Subhash Chandra and another versus Delhi Subordinate Services Selection Board, the Supreme Court has held that as a general rule, only cases in which decisions should be held to have been given per incuriam are those of the decisions given in ignorance or forgetfulness of some statutory provision or some authority binding on the court concerned. So that in such cases, some features of the decision or some steps in the reasoning on which it is based is found on that account to be demonstrably wrong. So therefore, in sum and substance, what we know about this doctrine of per incuriam is that if a case has been decided without taking into consideration the relevant statutory provision or the judgment which have a binding force upon the court concerned, the said judgment cannot be treated as precedent. These principles of per incuriam is against the hypothesis of a rule of stare decisis, which rules that a judgment of long standing has to be followed but even if it's a judgment delivered, it has quite some time back, but it uh, but it is found that